Daza. Hindi ko po tatanungin ang ating testigo. Just very simple. Article 7 charges that Chief Justice Corona it was partial in favor of former President Arroyo, which, as you say in your impeachment complaint, constitutes betrayal of public trust. Is that correct?
That's correct.
Yes. May this representation be enlightened as to the degree of partiality and or bias that will warrant such removal from public office of the Chief Justice. In short, I want to understand the threshold of bias and partiality that the Chief Justice exhibited that would warrant his conviction and convince this court that as far as Article 7 is concerned, he has to be convicted on this count.
Yes, is the question of the distinguished senator whether the conduct of the Chief Justice amounted to betrayal of trust? Is that the thrust of the question?
I will repeat my question, Mr. Prosecutor. What is the threshold of the degree of bias and or partiality exhibited by the sitting Chief Justice that would warrant him removal from office if and when he is convicted by the impeachment court?
Well, the partiality should be proved by the quantum of evidence that is somewhere between substantial evidence and proof beyond reasonable doubt. It's somewhere between that.
Substantial
yes,
evidence and proof beyond reasonable doubt.
Somewhere
but that covers already the whole spectrum.
No, somewhere between that.
Clear and convincing evidence, perhaps?
The problem is that I've been researching, although not as thoroughly as the distinguished presiding officer. I have not found from my research, either from U.S. authorities or from authorities in the Philippines, which fixes that quantum of evidence necessary to convict in an impeachment trial. It is just that it's somewhere between
I will rephrase my question.
Evidence.
I understand your answer. However, I completely want to understand.
With the permission
Yes,
of the
Mr.
lady
Presiding
senator.
Officer.
If you study Charles L. Black, Jr., written, who is from Yale, and Raul Berger, who is from Harvard, you'll see there that it would seem that the requirement of the quantum of evidence required this overwhelming preponderance of evidence. Although there are indications that clear and convincing evidence is enough. So anyway, that will be a matter that will be discussed in due time.
To confess, in all candor, I'm unable and I'm not competent to answer that question with
certainty.
credibility. I wouldn't want to answer that in a manner that I would
That is
be
fine, Mr. Prosecutor. We appreciate your candor.
I think if I don't know whether I think the question, as I understood it, is asking what is the degree of partiality that will equate into a betrayal of
Public trust.
Yes. Was it repeated partiality? One partiality? Two partiality? Three partiality? I think that's the...
The presiding officer is correct in trying to interpret the question which I posed before the prosecutor.
Well, if all the individual acts or actions of the Chief Justice in relation to the TRO that has been the subject of the testimony is proven by sufficient evidence, whatever is the quantum that may be decided by the court, it is our humble submission that that would constitute betrayal of public trust.
Anyway, when the defense turned to present their evidence will come, I assume that they will, a witness from their side will be presented to explain many of these things that are being discussed now. So we will see at that point which one is the more weighty story against the other. Okay?
Yes, let me ask the question insofar as this TRO is concerned with regards to Article 7. What did the Chief Justice manifest or do that he is being charged with betraying public trust through his biased action, opinions, decision, or his so-called partiality?
Well, as testified to by the witness and from my reading of the dissenting opinions, there were individual acts of the Chief Justice that together, when put together or pieced together, would show that partiality. Among others, one, the fact that because he had the power or authority to decide on the agenda of the court, the two consolidated petitions were agended, shall we say, with some speed. I wouldn't want to say indecent speed. Number two, being the Chief Justice, it was within his authority under the internal rules to order that the respondent, Secretary of Justice, and the other officers be first required to comment on the petitions, even if given due course, with the end of view of considering the TRO. Number three, the ponente to which the two petitions were assigned on the issue of TRO recommended a hearing, and yet that recommendation was not heeded. Well, of course, number four, as testified here just this afternoon, on two, at least occasions, his spokesperson, Mr. Marquez, misrepresented what really happened within the court, and yet his spokesperson, Mr. Marquez, was never corrected for the interest of the public on those erroneous announcements. And plus, another is the matter of the efficacy of the TRO was assigned to Justice Velasco as ponente. The understanding was that he was going to sit down with Justice Carpio on that clarificatory order. But the Chief Justice on his own broke that and then put on his own version of the clarification of the temporary restraining order and several other acts. Now, one act we submit is not sufficient to prove partiality. But when there are so many acts and all of them show a pattern that would show favoring the former First President, we humbly submit, Madam Senator, that the proof of partiality there is strong. And that if we submit, this impeachment court agrees with the version of the prosecution based on those facts, even only on this count, because there was betrayal of public trust, the Chief Justice should be removed.
Ang sinasabi ba ninyo, Mr. Prosecutor, na dahil sa kanyang pagmamabilis ng pagbigay ng TRO ay una, minadali, pangalawa ay minaniubra niya ang desisyon nito para paboran ang dating Pangulo.
Tama
so
po
in
yun.
sum, yung inyong 5 minutong paliwanag ay isa sa ilalim sa isang sila, minaniubra bilang Chief Justice ang desisyon? Ganun ba ho?
Ganun po.
Sa-
Ito po yung nangyari nang dahil siya sa ilalim ng tinatawag na internal rules of the court, may kapangyarihan. That
Maski
he
po
will
collegial
get-
body ang
he
Supreme
will
Court.
get authority and power as Chief Justice to influence the individual justice. And not only that, as I mentioned, gaya po na nasabi ko, talagang lantad, tahasan po, na talagang sa kanyang ganang sarili, pinakialaman pa niya ang gawain ng kapwa magistrado ng Korte Suprema.
Gusto ko pong maintindihan kung paano po niya inumpluwensya ang desisyon ng ibang mga kasamahan niya sa Korte Suprema para po bumoto sang-ayon sa kanyang, ayon sa inyo, pananaw.
Hindi, kanya nga po ang ginang senador.
Did he bribe, coerce, harass any of the members of the court?
Hindi naman po kailangang takutin o i-harass ang kapwa magistrado. Alam po naman natin na sa takbo ng buhay, hindi lamang sa Korte Suprema, kundi sa anumang pangkatin sa ilalim ng ating pamahalaan. Pag ang isang namumuno, lalong-lalo na ang punong magistrado, gamitin ang kanyang kapangyarihan, ang kanyang influensya sa kapwa magistrado, hindi na po kailangan takutin. Bulungan lamang, kausapin lamang.
At yun
Pero
po ang
mahalaga
sinasabi
po,
niyong
Madam
ginawa niya.
Senadora, ang mahalaga po hindi po yung kose, kundi yung epekto po yung nandyan The reality of what happened, how it happened, is not really as important as what really happened.
Thank you, Mr. Prosecutor. Sa takdang panahon po ay pakikinggan ko naman ng depensa ayon sa sinasabi niyong pagmamaniubra ni Chief Justice Corona sa pagbibigay ng TRO in favor of former President Corona.
Maraming salamat po,
po.
ginang senadora.
Justice Floor Leader.
Finally, Mr. President, the Minority Leader, Senator Alan Cayetano.
Senator Cayetano.
Magandang hapon po, Mr. Senate President, sa ating po mga colleagues. May mga tanong lang po ako to clarify.